كلية الفقه الحنفي تقدم
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to lesson number 3 of this chapter on dividing assets. What we're going to do today is there was one point left from the last case that we were discussing yesterday, so I'll complete that. Then it's going to be the discussion of dividing different assets. So how do you divide assets? So it would then depend obviously on whether they're all the same assets, same category of assets, same type of assets, or they're like a different a variety of assets. So how do you do that? And then how do you divide animals, and how do you divide what they discuss as slaves and pearls and gems and other valuable items like that. So that's what we're going to do today, inshallah. Allah assist us and help us, and Allah allow us to benefit from him, from this, and Allah bless all of these authors of the past who have taught us and our teachers. May Allah subhanahu wa ta'ala bless them all and allow us to follow in their wake. So he says, so just to finish off that issue from yesterday, which was that there's a partners, and one owns more of the asset than the other one, and it's such a case where if they go with the final discussion was that if the guy who has the majority, and if he can continue to benefit from his asset even after distribution, he asks for separation, he should get it. Whereas if the guy who has a small amount, which would be kind of worthless if it was divided, and he's still obstinately asking for it, then the judge should not oblige and should not divide it, because he's just being silly, right? So it says, وَإِنْ كَانَ كُلُّ وَاحِدٍ مِّنْهُمَا يَسْتَضِرُّ لِقِلَّتِهِ, that if the whole asset was a very small one, not very significant to start off with, and it had two owners, two partners, and it was, making something right now of some value, but if they were to split it, then it'd become just like shreds and it wouldn't be valued. And for some reason they just want to separate, right? Because sometimes it just happens, right? لَمْ يَقْسِمْهَا إِلَّا بِتَرَاضِيهِمَا, and one of them asked to separate in this case, and they're both going to be harmed, then it would be the same as the previous one. The judge is not allowed to separate there, إِلَّا بِتَرَاضِيهِمَا, unless they both agree. Yes, if they both agree that we just want to be separate, even if we don't benefit from this, even if we're harmed by this, then the judge will have to oblige. لأن الجبر على القسمة لتكميل المنفعة وفي هذا تفويتها, because in this case, if only one wants to separate and the other one doesn't, then it's like you're forcing the other one to do so, and nobody's getting a benefit. So there's no point compelling something when there's no benefit on either side, right? However, it's allowed if they both agree, because it was their right to have it together or to separate, whether they are benefiting or harmed. So if they want it to be separated because they've got good consideration for that, then judge will just do it for them if they both agree. Now what they're going to discuss here is, when has the judge the right to just divide things, and where there needs to be some kind of mutual agreement. So that would depend on the variety of the products, or if it's a singular product, right? And because he has to look at harm as well, for the benefit of everybody. So Imam Quduri says, وَيَقْسِمُ الْعُرُودَ جَمْعُ عَرْضٍ كَفَلْسٍ خِلَافُ الْعَقَارِ. So this is talking about any other movable assets that are not seen as a piece of land or something, right, or a building or something. إِذَا كَانَتْ مِنْ صِنْفٍ وَاحِدٍ. So it's just all horses, or it's just all sheep, or it's just all laptops. So it's a business, right, that was inherited or that they purchased, or stock or something like that. So if it's all one category, then the judge will just split between them, because he can, because لِإِتِّحَادِ الْمَقَاصِدِ, the purpose of all of these things are the same. So nobody's going to get more than the other, except according to what their share is, right? فيحصل التعديل في القسمة والتكميل في المنفعة. So now they can both individually, independently benefit from their portion, and they can still benefit from it. So there's no harm in that, right? ولا يقسم الجنسين بعضها في بعض. However, if they jointly own two different types of assets, now, of course, if he can split the dates separately and you can say the pens or the books separately, then that would be easy to do. However, if it's لأنه لا يقسم الجنسين بعضها في بعض, he can't divide two categories of products, some for the other, because who takes the pens and who takes this if there's not enough to split them up, for example, right? So if there's just one laptop and there's just one animal, for example, لأنه لا اختلاط بين الجنسين, because the objective of each is different. So how is he going to separate in a way that they can, in a forceful way, in a way that they both can still retain the function and the objective of it? That's essentially the question. So it's going to be difficult to divide between them in a way that secures that. So that's why in such a thing, it's going to be the portion of mine in there for the portion of in yours. So if they want out, they can't continue to both own the horse, and they can't continue to both own the car, right? Right now, they both do. So the judge can't say, okay, you take the car, you take the horse, because objectives of both, purpose of both are different. And that is going to be seen as, remember, it's not just a separation, but it's actually a compensatory kind of settlement. You take my portion in there. That you need agreement for. So he's going to have to sit them both down, and they're going to have to do it together. Okay, I'll take this, I'll take that, I'll give you some money extra, or whatever the case is. Okay, what about, then Imam Abu Hanifa says, لا يقسم الرقيق ولا الجواهر لتفاوتها. What are assets that are considered to be not equal that you can just split between them? So if you've got lots of dates, they're usually very, very similar to one another, so there's not that much disparity between them, so you can separate between them, right? Easy. Rice you can separate. Likewise, you can separate wheat and all other things of that nature. If it's pieces of things, like for example 50 Samsung phones, right, of the same type, or 50 iPhones or whatever of the same particular type, you know, 25-25 is very simple. But there's some things with a lot of disparity. So he says, if it's slaves, each slave is different. They're not all the same. They don't come off a factory. They're human beings. Wal al-jawahir, or pearls, gems, they're all different sizes and different cuts and different carats and different values, and they have different luster and so on. They're too disparate. He says that because in the human being, it's very, very disparate in humans. Because a human is not just looked at for what they in numbers, they looked at for their inner qualities, for their behavior, for everything else. So they're going to be seen as multiple different types, even though they're all human beings. As opposed to animals, he says, when they're all the same, it's like loads of sheep, there is a way to say, okay, you get fat, you get you know, 3 fat ones, and you get 3 fat ones, and you get 2 thin ones and 2 middle ones, or there's one, and then there's just 1 fat and 1 thin, so okay, you'll get 2 thin and 1 fat one. There's ways to sort that out, because there's not, the inner dimension is not looked at in terms of sheep, right? The behavior of sheep, because they're pretty standard usually. Okay, you might get one that's a bit off track or whatever, but otherwise and then he says that when it comes to small diamonds and other gemstones and that, again, there's a massive variance and variety in that. So that's worse than the human being in terms of difference and variety. So that's why you can't just, unless they've all been so well organized and categorized and split up that it's all of a certain carat. You know, they've come from a production facility that has graded all of them and they're all the same, right? You know, because I wanted 50 of them for 50 rings and they're all exactly the same size, and obviously that's very simple to split up. But I hope you're getting the gist. So Imam Abu Hanifa is very particular about that these things cannot be split up by force. They have to agree. Imam Yusuf Imam Muhammad says, when it comes to slaves, we're going to see it the same as any other animal, right? So you can split between them. Just try to give, you know, size-wise or whatever it is. And when it comes to the gemstones, we don't know exactly what they said, but it has been stated that when it comes to gemstones, if they are of different gems, one's a diamond, one's a sapphire, some are rubies, then he can't divide them. Sorry, this was about pearls. If it's about pearls, right? So we weren't talking about gemstones overall. It was just about pearls in particular, which can be of different variants. But Sahibain's view, it seems on there, is that if they are of different types of pearls, then they should not be split up, just like you won't split up other rubies, etc. Right? Another opinion, yeah, I think there's no agreement on this. I think it all depends on what they look like and, you know, if they can be split or not. So another view is لا يقسم الكبار منها, the big ones, they should not be divided, because in the big ones in the larger ones there's usually more variety, whereas the small ones, they usually don't have that much variety and they can be split up. Another opinion that is being mentioned is that no, you're not allowed to split them up at all because there's just too much variance in there. Again, I think today, if they had been properly graded and they all come all graded and everything, and they're all the same in their grade, particular carat, etc., then it should not be a problem, right? Anyway, Imam Bahauddin says in his Sharh, Sahih opinion is Imam Abu Hanifa's opinion. Mahbubi, Nasafi, Sadr Shari and others have relied upon that opinion, which was the first one, is that you can't split up slaves, you can't split up pearls, right? Because they're just too... So I think today is simple, that if they are similar to one another, then you can split it up because it won't have an effect on any of them. Right, next point here is Bayanu ma yuksam wa ma la yuksam. Chapter on what can be divided and what cannot be divided. Right? What's the point of dividing a car in half? As we discussed earlier. So these are the things he's saying. وَلَا يَقْسِمُ, these things cannot be divided. حَمَّامًا وَلَا بِئْرًا وَلَا رَحًا. A single bathhouse, a hammam, a single steam room, can't divide that. Because by splitting in half, it's not going to remain. There's not enough space in there to fire the logs up and everything like that. So if it's something that's going to lose its usufruct and purpose, then wala bi'ran, you can't split a well, right? It's very difficult to split a well, I guess. Wala rahan, you can't split a mill because you need that whole circumference of it for it to work. What are you going to do with half of that? You know, you can't just go halfway around, semicircle. Wala kullu, now if there is a way to split any of this and to continue its purpose, then you can. Because what this is based on is the fact that they will lose their usufruct. وَلَا كُلَّ مَا فِي قَسْمِهِ ضَرَرٌ لَهُمْ. Likewise, anything that would be harmed and damaged and usufruct lost by division, كَالْحَائِطِ بَيْنَ الدَّارَيْنِ. How do you split a wall between two properties? Chop it in half like that, then it's going to become too flimsy, if you can even do it. Well, kutub, what's the point of splitting up a book in half? Okay, you take the second 100 pages, I'll take the first 100 pages. Yeah? Or you take the top half and I take the bottom half. It's just crazy, right? The explanation for that is لأنه لا يبقى كل نصيب منتفع به انتفاعا مقصودا فلا يقسمه القاضي. Because each one of those sections now, divided sections, would not remain beneficial in the way that it was earlier, in its main objective benefits. That was the purpose of it. So that's why the judge can't do something harmful like that. They have to just decide between them what they're going to do. One guy buys the other out, or sells it to another person. He can become a shareholder. He can become a partner with him, right? Or something like that. Now you might say that, but there may be some other purpose of it. So if there is another purpose of it, then that's different. Then they can agree to do that. But the Qadi can't force that kind of division on the other person. Yeah, if they both agree, then they can do whatever, even if it's harmful. That's no problem. We all agree with that. Everybody agrees with that. Because they can just use it for something else, or they just may not want to see each other's faces again. But if it's just one asking, then you won't do it. All these discussions until now was when one person is asking, then can the judge force it on the others? So in this case, no, because it's going to lose its main purpose, even though the guy could maybe do something else with it. He can make it a storeroom, but then that's not really the main purpose of it. The main purpose of it was as a whole, so either they agree or they just sell to buy each other shares out, or one another shares out, or whatever it is, or do something else. بخلاف التراضي كما مر, as opposed to where they're both happy for it, then it's completely okay. ولذا قال إلا أن يتراضى الشركاء, unless the two shareholders or partners, they agree, لإلتزامهم الضرر, because then they are willing to take on the liability of the harm. That's fine. وهذا, but that is only إذا كانوا مما يصيح التزام الضرر وإلا فلا. This is only if they have the capacity to take on a liability of that. If they're not children, for example, children are not allowed to take on liability of a harm. They can only do things in their assets that are purely beneficial, right? وإذا حضر وارثان, if two inheritors become present, or they come in front of the judge, وأقام البينة على الوفاة, they establish that the deceased has died. They establish that. وعدد الورثة, they also establish evidence that there's only these two, that there is this number of inheritors. So that first case we had dealt with, but in the with all the proof here. وَالدَّارُ أَوِ الْعُرُودُ بِالْأَوْلَى فِي أَيْدِيهِمْ, and the asset, whether that's a house or a property or a land or anything movable, a phone or a car, is in their possession. However, they've established that they are inheritors along with the third person who's not present. So they're clear about that. They've made that very clear. They've put proof up for that. Or one of them is saghir. So it's not a person who's absent. They're all present, but one of them happens to be a minor. He's only 7 years old, or she is 8 years old. قسمها القاضي بطلب الحاضرين. So in this case, interestingly, the judge will divide, right? The judge will divide between them by the demand of the two who are present, and he will just put up a representative, a lawyer, a person to stand for on behalf of the absent person. So in this case, what you have is وَيَنْصِبُ لِلْغَائِبِ وَكِيلًا, he'll put up a representative on behalf of that absent one, and he'll also put up a representative on behalf of the child as well, that can take possession of their share. So you see, everybody's asking, so, and they've established evidence, so he will do it, but have somebody represent the absent person so that it doesn't become, so in certain cases you're allowed to make that judgment like that by putting somebody in their place, by deputizing somebody to represent them, like a solicitor or lawyer that would be independent, so that it's to everybody's benefit. ولا بد من إقامة البينة على أصل الميراث في هذه الصورة عند أبي حنيفة أيضا. Imam Abu Hanifa says, and this would only be the case if they have established evidence that this was inheritance and the deceased has passed away. لأن في هذه القسمة قضاء على الغائب والصغير بقولهم خلافا لهما, because again, otherwise it would turn out to be a judgment against an absent person. So in order to make it work and benefit everybody, he's allowed it to happen as long as they have evidence, but then to see it through, he's put a representative in place of the absent person or the child. Right? This was the case of inheritance. وَإِنْ كَانُوا مُشْتَرِينَ. On the other hand, see, because ultimately it's inheritance, so the deceased is gone anyway, and they've established that, so there can't be anybody to come and ask for anything else, usually speaking, right? And the person who's not there, he might not be there for a year, so what's going to happen to the inheritance? It's going to sit there and it's going to rot. Or it's just nobody can benefit from it, even though it becomes the inheritors in a sense, as I explained earlier. So that's why he'll just do it, but he'll put somebody there to represent their rights. Now, if they had claimed otherwise, that no, we purchased this. So 5 of us purchased it, only 4 of them are there. the fifth guy is not there, he's gone out on holiday or something, he's just not present, then he says that if they were purchasers, then he can't, with the absence of one person or anybody of them, he will not separate between, so he will not make that division. Why? Why would he do it in inheritance, but why would he not do it here? والفرق أن ملك الوارث ملك خلافة حتى يرد بالعيب ويرد عليه بالعيب ويرد عليه بالعيب فيما اشتراه المورث ويصير مغرورا بشراء المورث فانتصب أحدهما خصما عن الميت فيما في يده والآخر عن نفسه فصارت القسمة قضاء بحضرة المتخاصمين. So in the case of, again, there's a huge technicality which I've already explained to you before. So he's saying that when it comes to the case of inheritance, right, the people who have come to secure their inheritance, their ownership is like a subordinate ownership at this point to the owners, the deceased ownership, because the deceased still is considered the owner, but because it's coming to these people and it's their right, they are, you can say, subordinate in their ownership until it becomes distributed, right? Such that, let's just say, the deceased had just purchased something or had sold something and he's got the money for it, and then it turns out he died, and then it turns out that it was defective, that product. So the guy who bought it will come back to return it. He has a right to return it, so he's going to have to give them money. The money is going to have to come out of this inheritance. And likewise, if the owner had purchased something, if the deceased had purchased something before his death, then he died, and it turned out to be defective, they can return it. So there's lots of possible scenarios in this case. So that's why, because of the possible problems of this area, they've put somebody in their place, to stand in their place, to look at their right. And they've also taken into consideration the people who are demanding the separation. So that's fine. They've allowed that in the inheritance case. You don't want the inheritance just to sit around. Whereas when it comes to al-milku thabiti bishira, the case that we're looking at where they had purchased the item, that means that they're not subordinate owners. They are owners, primary owners, because they're the ones who purchased it. It's no longer the ownership of the seller. He's transferred it. Right? Remember, in the inheritance, the ownership remains that of the deceased until it has been distributed, and they're asking for the distribution, so it's still in that state. Whereas when they've bought it, they outright bought it. They are outright owners. They're not subordinate owners. That's why there's the technicality they mention here. If I sell you something and then you sell it on to somebody else, and then he finds a defect, he can sell it, he can bring it back to you, but he can't bring it to me because you had already benefited. So that's why in this, once you've sold it, it becomes a separate, it's like seen as a separate entity, so there's no problem here. فَلَا يَصْلُهُ الْحَاضِرُ خَصْمًا عَنِ الْغَائِبِ فَوَضَحَ الْفَرْقِ. And in this case, you can't have somebody else stand in place of the person who's absent, so it's not going to be allowed. The main thing that we have to remember here is that if they had purchased it, then it's not allowed to be divided, right? Without everybody's presence. But in an inheritance case, they would allow it as long as they've got the proof and so on, and they've established that the other person is the inheritor as well, but he's just not there, and the qadi will just put a person in that place, right? وَإِنْ كَانَ الْعَقَارُ أَوْ شَيْءٌ مِنْهُ فِي يَدِ الْوَارِثِ الْغَائِبِ. Now what happens if they didn't have that entity, that asset in their possession, but it was actually in the possession of that third person who's not present? So they're saying that he is part of our shareholders, but he's our partner, but he's not present. then again the judge can't make a decision on this one, because that would be seen as deciding on somebody else, and that is not allowed. Whether they establish proof or not makes no difference in this case, because it's not even in their possession, right? This would be just too sensitive of a case. وَإِنْ حَضَرَ وَارِثٌ وَاحِدٌ لَمْ يَقْسِمْ وَإِنْ أَقَامَ الْبَيِّنَةِ لأنه لا بد من حضور الخصمين لأن الواحد لا يسوء مخاصما ومخاصما كان قاضٍ. Right. So remember, in most of these cases, when it comes to inheritance, you need at least two people. So one of them can stand as the claimant, and the other one can stand in place of the deceased as the defendant and let the process take place. If only one, there is only one inheritor, or there are two inheritors but only one is present, then the judge can't do anything, because there's no two people. He doesn't. He has to make he has to have at least two of them, so that one of them can become in the position of the defendant. So that's why he's saying that if only one warith became present, then the judge will not make a decision for division, even if he has all the proof, because you have to have at least two people, so that one can be the defendant and one can be the claimant, right? One can be the one who's asking for it to be split up, and the other one who's then finally agreeing for it to be split up. It's just the process, right? So yes, if there were two people, it's fine. If two came, that would be fine, because then he can put one, okay, one of you choose to be the claimant, we're going to get there, and then you got the proof anyway. So that's what it is. The Lubab has many other scenarios related to that, which I'm not going to go through, right? As the primary book that we're covering is the Quduri, so I'm not going to go through all of that, because it's that what happens if one of the bigger inheritors is present and somebody is there who has been who stands to gain up to 1/3 or something through a bequest, and they're asking, can they do it? So yes, in that case, as long as they both provide evidence that one's an inheritor and the other one stands to benefit from it as a bequest, right, up to 1/3, right, of the will, then the judge can make one on one side, one on the other one, and he will do that. He will allow that to go through. And then there's the case of the child, and if he has a representative, and so on and so forth. But I'm not going to go into all of that, because it's not necessary right now. I don't think so. وَإِذَا كَانَتْ دُورٌ مُشْتَرَكَةٌ فِي مِصْرٍ وَاحِدٍ. Now this is going into houses. So it's a guy who died, he's left lots of assets, lots of property, and it's all in one area. It's all in one town, one city, one, when you say city, one small area, right? One borough, one city. So for example, we would treat every borough of London as a separate city, because it has its own council, it has its own force, it has its own laws, etc., right? Likewise, in any big city, Manchester might be like that. Likewise, Birmingham might be like that. Small towns or smaller cities just have one. Likewise, New York is a collection of different cities. Likewise, Chicago is. Likewise is Los Angeles for sure. San Francisco, Istanbul maybe, So it just depends. If they are all separated out, then each one, even for traveling purposes and so on, whether a person becomes a musafir or muqim, we treat them separately. Because while they do have the greater London, greater Chicago, greater Toronto, or those areas, and there are some rules that apply to all of them, a lot of the time it's Brampton, Toronto is separate from another area, so they have their own kind of bylaws and things like that. So he's saying that if there were property that they were all shares, they were all shareholders in one city, قسمت كل دار على حدتها في قول أبي حنيفة. Ya Allah. So the question here is, the discussion here will be that, do you split each of the houses? Or do you split the houses based on, okay, you take that one, I'll take this one, and you do some kind of arrangement of that nature? That's the discussion. So according to Abu Hanifa, he says that each one of them will be split separately. لأن الدور أجناس مختلفة, because when we say house, it's like an estate almost, like multiple dwelling places in one large kind of house where multiple people can live in, right? That's what he means by a dar. So dur, okay? Because you have the word dar, you have the word manzil, and you have the word bayt. Bayt is just one room, like a studio flat. A dar is where it can be split up into a multiple occupancy unit, right? So he says that dars and these, you know, multiple occupancy units or whatever, they are of different types because each one of them have a separate purpose based on where they are, based on the neighbors there, based on zoning laws or licensing laws or permits of what you can do and what you can't do in all of these places. How close it's to the masjid, shopping center, station, water facilities, bazaar. So that's why you can't say, okay, I'm going to give you that one, I'm going to give him that one. Because one might be closer to a station, have more value than the other one for that person, right? So you can't do that. So that's why each one of them has to be split up. If they can't agree, then okay, you take half of that and I take, and it's big enough to split up. But it's going to become two bedrooms each instead of 4 bedrooms. Okay? Sahibain say, الرأي فيه إلى القاضي, that there's not one way of doing it. Leave it to the judge, whatever he thinks better. إن كان الأصلح لهم قسمة بعضها في بعض قسمها كذلك. If it is better for welfare and it's more conducive for the two to divide it by giving some for another, and the compensatory style of one for another, and he takes this and he takes those 2 smaller ones, then he would do it that way. وإلا قسمها كل دار على حدة. Otherwise, if it's not possible to divide it that way, that okay, you take that large one there and he will take the 2 small ones there, right? And the value of them kind of come out, because we can evaluate it these days, right? And again, remember, this is when they can't agree to do it themselves. The judge, this is when one of them asks for it to be forced, right, to do it, then in that case. So he's saying that then otherwise he'll just have to split each one of them down the middle as such. لأن القاضي مأمور بفعل الأصلح, because the judge, his responsibility is to do that which is the best for their welfare, مع المحافظة على الحقوق, while trying to preserve their rights. Okay? Isbijabi says, الصحيح قول الإمام. Imam Abu Hanifa's opinion is the sound one. وعليه مشى البرهاني والنسفي وغيرهما. So all of these agree with him. Hidayah says that because Imam Quduri mentioned that they're all in one area, that implies that if they were not in one area, but one were somewhere in this area, somewhere in another city or a town or another part of the city, then this same mas'ala will not apply, because a house in another area is completely different purpose and usufruct to a house in this area, right, in another area. Imam Muhammad says, أنه يقسم إحداهما في الأخرى. Imam Muhammad even in this case allows them to be shared in the compensatory style, where he gives 1, 2 there and 1 here, as long as that can be done. وإن كانت دار وضيعة أي أرض أو دار وحانوت قسم كل واحد على حدته. From here he starts on another mas'ala, which inshallah we can complete today, is that let's just say that within the inheritance there is a large dwelling, multi-occupants, then there is a piece of land, or there's a multi-occupant building and there's a store. I mean, a store here means like a retail unit, okay? Then each one of them, also you can't give one person the store and one person that, because they need somewhere to live and one person needs somewhere to do business. So you can't do that, because then one person will have the residence and the other person will have the store. That's not benefit. Where's the guy going to live who has the store? And the guy who has the house, where's he going to get money from? Right? They both owned it. So he's saying that you have to split each one up, right? So you'll get half the house and half the store. Why? Because they're all seen as separate categories. So when it's separate categories, you can't mix them up that way, right? You have to give each person a portion of each. In the Durar, ad-Durar wal-Ghurar, which is one of our other texts of fiqh, he says, ها هنا أمور ثلاثة. We have three possibilities here, right? One is you have the multi-occupancy homes, you have individual units or individual, you can say studios, and you have manazil, which should be a flat within a home, a flat, like one bedroom apartment within a larger building, right? So a manzil comes in between a full-fledged multi-occupancy house and just a flat, one studio, right? Small room, right? Or small dwelling, okay? So it's in between the two. So I think what you'll understand is that he says فَالدُّورُ مُتَلَازِقَةٌ كَانَتْ أَوْ مُتَفَرِّقَةٌ لَا تُقْسَمْ عِنْدَهُ قِسْمَةً وَاحِدَةً إِلَّا بِالتَّرَاضِي. So in the Durar, it's mentioning that the multi-occupancy properties, whether they're linked to one another, according to Imam Abu Hanifa, they can't be divided they can't be divided one for another except by mutual consent, right? So they would have to be split down the middle because they all are seen as separate. On the other hand, if they were just rooms that the guy had left 5 studio apartments, in those days they were quite standard the way they were. They weren't major size and other differences or facility difference. They were quite simple, just dwelling places. You brought a bed in there and you just lived there. The decoration and that wasn't a big deal, right? So he's saying that those they can be swapped and divided completely because they're very similar in terms of their residency status. They're very, very similar in terms of their dwelling status. So studios, he says, they can be swapped for one another and so on. They don't have to be divided in half. Whereas the dar, which was the multi-occupancy dwelling, that has to be split up because if you had swapped those and gave one person this one, that one, that could cause problems. What happens to the manzil, the flat, like 1 bedroom, 1 kitchen and a living room? So this is like bigger than just one studio flat. He says that neither falls here, neither falls there. It just depends on what it falls under, what it's closer to. He says that if all of the if the bedroom and the living room and all of that was in one part of one larger house and they're all together, they're all interconnected, then that would be more like the house. That would be more like the dar, which means the multi-occupancy place. So that would have to be split up in half, right? Or however the proportion is. Otherwise, it can be traded, right? Because then in that case, it is more like the studio apartment. Right, that was Imam Abu Hanifa's view. Sahibain, they say, في الفصول كلها ينظر القاضي إلى أعدل الوجوه. The judge is going to decide as what is the fairest way to divide this. He may take some consultation with some real estate agents or whatever the case is. ويمضي على ذلك, and that is how he will proceed. وأما الدور والضيعة أو الدور والحانوت فيقسم كل منها وحدها لاختيار الجنس. So that difference of opinion only came about when it was different residences, types of residences, sizes of residence. If it's homes and a piece of land, or homes and a storefront, a store unit, selling place, retail unit, then each one of them you can't mix them up. Then it means that the 2 or 3 partners, they'll have to get 3 sections from each of them or 2 sections from each of them, depending on how much they are, because they're all seen as different categories and you can't swap them from one another. Otherwise one person will be left with a home and the other one will be left with a store or with a piece of land. Where is he going to live, right? So that's how that is. Inshallah, that ends our 3rd lesson, where we will carry on with how the division will be done now. He's getting more into that as opposed to now just the portions that he discussed or the major portions. Now he's going to be discussing how you actually make the division in a lot of these things. So Jazakallah khair. Allah bless you all. Keep us in your du'as, inshallah. Assalamu alaikum wa rahmatullahi wa barakatuh.